Welcome to the 21st episode in the first season of Justice Center Weekly, the video cast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me is John Carpay, the president and founder of the center. John is here to talk about some Justice Center winning. The Justice Center is at the center because we helped fight the Ingram case, which was a challenge to the Alberta health orders during the COVID lockdown. And since that ruling, which struck down those orders, charges have been dropped against brave citizens who protested the government edicts when they were announced. So John is here to take a victory lap on behalf of the Justice Center, its supporters, and those freedom fighters now set free. John, over to you.
Well, July 31st, the Alberta Court of King's Bench released its ruling in Ingram versus Alberta, which was a challenge to the government's lockdown measures. It was filed in December of 2020. The court was disgustingly generous in allowing the government 6 months to provide evidence, which proved to be very weak. It was models and speculation. 2.5 years later, July 2023, we finally get a ruling. The court struck down all of the lockdown measures. The court's reasoning was that the health orders ought to have been issued unilaterally by the chief medical officer without any substantive input from the government of Alberta. But the testimony of Dr. Dina Hinshaw, the chief medical officer of Alberta, in court had been that these were fundamentally the orders of Jason Kenney and the cabinet, and that she was merely advising them, but they were the decisions of the cabinet. And so the court's interpretation of the Public Health Act is that these health orders ought to have been enacted uniquely by her. Not that she couldn't talk to the premier, but that they were to be her orders, not his orders. And on that basis, invalidated the orders. Now, quite sadly, I wish I could say it was, across the board victory, but the court said that the violations of our charter freedoms of conscience, religion, association, peaceful assembly, expression, and so on were justified, but she failed utterly and completely to canvass the lockdown harms and to do a proper balancing act, which the courts are required to do, because the onus is on the government to show that its laws that violate charter rights and freedoms are actually doing more good than harm. And the government certainly didn't establish that. And there's no evidence in the court ruling that Justice Barbara Romaine seriously considered lockdown harms at all. She operated on a general impression that, these measures did more good than harm, and that's it. And there's no analysis of, for example, mental health damage to children, people robbed of their living and of their livelihood, life savings destroyed, massive increases in drug overdoses, deaths from drug overdoses, increases in cancer because the chief medical officer canceled surgeries and diagnostic procedures, et cetera, et cetera. There's no analysis there. So it sadly comes to a conclusion that it was a justified violation of charter freedoms, but there's no serious consideration. There's no serious analysis as to why or how the judge arrived at that conclusion. So it's mixed. Now, on the positive side, because these health orders were invalidated, I'm delighted that the prosecutions against Pastor James Coates and his Grace Life Church, and prosecutions against Pastor Tim Stevens and Fairview Baptist Church have been discontinued. And so these men and so many other Albertans no longer have the cloud of a prosecution and upcoming trial hanging over their heads.
Yes, and one that actually wasn't our case, but worth mentioning is the Whistle Stop Cafe. That was a big story across the province as well. And the owner, Christopher Scott, actually was acquitted. And apparently there were cheers out in the courtroom when that happened. The judge said, "You're free to go." And I guess that sent hats into the air as everybody was celebrating. So yes, even though that wasn't ours, that was one of them.
These people are amazing, and they deserve our gratitude for being light in the darkness and speaking truth to power. I mean, all of these lockdown measures are based on the false claim of Dr. Neil Ferguson of Imperial College London and politicians like former Alberta Premier Jason Kenney, who falsely said that COVID would be as bad as the Spanish flu of 1918. The assertion's false. We knew it was false by May of 2020, 2 months into lockdowns. It was abundantly clear to any thinking person willing to look at the evidence that there's no justification for violating our rights and freedoms and pushing people into isolation and loneliness and depression, because all of these measures are predicated on the false notion that COVID would be as bad as the Spanish flu of 1918. And it wasn't. COVID was on par with the Asian flu of 1957, the Hong Kong flu of 1968, and COVID was a tiny fraction of the amount of carnage that the Spanish flu inflicted 100 years ago. And so it is intellectually dishonest and nothing but disgusting fear-mongering to make a comparison between the two, and yet that's what the politicians and the so-called experts did to put the entire population into a state of unjustified and unwarranted fear. So it was, Pastor Coates spent 35 days in jail, Pastor Stevens spent 18 days in jail, Chris Scott, who is not a client of the Justice Centre, went through, I don't know what all he went through, but certainly it was, he is to be commended for his tremendous courage. These people were beacons of light in dark times and a tremendous source of encouragement to all kinds of people, myself included, to stand firm and to stand up for our charter rights and freedoms. Had it not been for Pastor Coates, Pastor Stevens, Chris Scott, and so many other good people, Art Pavlowski comes to mind as well.
The Northcott case. What about that one? Yes.
And Ty Northcott, yeah. No More Lockdowns Rodeo.
Yeah.
These are the people that make such a difference by speaking truth to power. So it's just great that these wrongful prosecutions pursuant to unjust laws are now being dropped.
Yes, I think that we should mention, you talked about it being dark times, but, it was also vilification by the mainstream media as well. They went through tremendous vilification in the mainstream media, painted as, people that are potentially going to, kill us all by their actions. I mean, it was just horrendous. And now we're seeing, I guess, the other side of it, and I'm glad we are, that's for sure.
I got to switch gears to something horrifically sad. On Thursday, August 24th, Sheila Annette Lewis passed away. This courageous lady had a terminal condition and needed an organ transplant, and the medical doctors in Alberta refused to put her on the waiting list unless she got injected with COVID vaccine. She was opposed to doing that because she was in frail health, and contrary to the media narrative, the COVID vaccines were still in clinical trials throughout 2022 and into 2023. So anybody who describes them as experimental is in fact speaking the truth. And so this was an experimental vaccine that she was not willing to take. And the situation got even worse in 2023. In March, she, at her own expense, on her own dime, she obtained COVID antibodies test, and she had requested this because natural immunity is stronger than anything that this COVID vaccine could give you. There's tremendous evidence to support that. There's other evidence that suggests that they're equally good, and perhaps there's also evidence that the vaccine is better. But I think the most persuasive evidence from what I've seen is that natural immunity will put you in better stead, especially if there's new or forthcoming viruses in the months ahead. So far, the evidence suggests that those who did not take the vaccine are going to be in better shape. Anyway, she asked the Alberta Health Services doctors to do a COVID immunity test in 2022. They refused. March of 2023, she presents them with this test that showed conclusively that she had COVID antibodies, that she had had COVID in September of 2021. She survived it just fine. This is at the same time that she has this terminal illness. She got COVID and survived COVID, and then she got it a second time. So there's no medical or scientific reason whatsoever. Further, by March of 2023, around that time, even the World Health Organization declared that COVID was no longer a pandemic or no longer a serious threat. So we're into 2023. She has natural immunity against COVID. She's survived it twice. COVID's not a problem anymore. And these doctors still refused to put her on the organ transplant wait list.
Yes, the story went international, actually. The story of her passing went international. I did see some of those articles from around the world. And in the National Post here in Canada, there were a huge amount of comments. I mean, there were over 1,600 comments on this story as opposed to the usual 400. And actually, some of it was pretty hard-hearted, but most of it was sympathy for her and her situation. I think there's a greater understanding. I don't understand why that wasn't extended to the doctors who made this decision, but at least in reputation, generally, Alberta is suffering because of that decision in the eyes of, I would guess, the world at this point because of it, and because the international press that has covered that story.
Well, it's unfortunate that Danielle Smith, when she became Premier in October of 2022, did not order Alberta Health Services to drop its unscientific discrimination on the basis of vaccine status. And, I don't know the details as to why. Or was she being deferential to the health minister? Was the health minister being deferential to bureaucrats? I don't know. I can't look behind the curtain, so to speak. But in my view, it would have been within the power of the premier or the health minister, the one, the other, or both, to simply tell Alberta Health Services that, as a matter of law, they are to cease their unscientific discrimination against patients who legitimately chose not to get injected with this experimental vaccine. So why that was not done, that's for her to answer. This is a blatant violation of the Nuremberg Code, of which the central principle is fully informed, fully voluntary consent on the part of the patient. Now, there's two arguments I've heard against that. One saying that because the medication was government approved, therefore it was okay to pressure and coerce and manipulate people into it by threatening to kick them out of university, threatening job loss, or not putting them on the wait list for an organ transplant because the medicine was government approved. Well, that's just ignorance of the code itself. There's nothing in the Nuremberg Code that exempts governments or that exempts government-approved medications. We have to remember that when the Nazi doctors performed experiments on unwilling patients during the Second World War, that those experiments were approved by government, the government of the day. The other argument that has been raised is that the Nuremberg Code applies to medical experimentation, not medical treatment. And I think that's just hair splitting, because the fundamental principle, whether it's a medical experiment or whether it's a so-called treatment, either way, the core principle of the Nuremberg Code is the fully informed, fully voluntary consent of the patient. That is the principle, and it has been violated by these Alberta Health Services doctors to their everlasting shame.
Yeah, if I could just expand it a little bit, it's a terrible loss in and of itself. But if you expand the issue to look at, Canada's reputation internationally, this happens at the same time that we're being, I guess, looked at askance because of our support for medical assistance in dying at the same time. So we're getting kind of this reputation as hard-hearted people, and this just adds to it, and unnecessarily, as far as I'm concerned. Anyways, yeah, so I guess I hate to say it, but we win some, and I guess we sadly, very sadly, lose some. But here's to Sheila Lewis's memory. Okay, we're going to move on. I guess there's something happening in Saskatchewan now, and I'm not up on this, but maybe you could bring us up to date, John.
So the Saskatchewan education minister announced in the past few days that the new policy, or perhaps it's a reaffirmation of an existing policy, is that children under the age of 16, if they want to use a different a pronoun, if a girl wants to be called he, him, his, or if a boy wants she or her, then parents are not to be notified. And if the boy wants to start using a girl's name or the girl wants to start using a boy's name, if they're under the age of 16, that parents need to be notified. And so this has a similar policy in New Brunswick, by the way. Bear in mind that under 16, you cannot vote, you cannot buy alcohol, you cannot buy marijuana, you cannot get married, you cannot join the military, you cannot drive a car. So this whole notion that that children are like adults and should be able to pick their own names and pick their own personal pronouns is out to lunch, frankly. Children are children. They are protected by parents for a reason, and that is because they are vulnerable and they need the protection of their parents. And we have to remember that the love that parents have for their own children is far, 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 far greater than any amount of love that political activists or politicians might have for other people's children. And so there's a letter from Egale, which is a national LGBTQ advocacy group, a legal warning letter to the Saskatchewan government, threatening to take the Saskatchewan government to court over this policy. I've got the 2-page letter here. It's on the internet and easily accessible. I Googled use of preferred first name and pronouns by students policy, and from there you can find this letter and find the policy. So I want to go through this letter in the remaining time because it's quite interesting. The letter reads, "We represent the UR Pride Center for Sexuality and Gender Diversity, a nonprofit service provider housed at the University of Regina. UR Pride supports 2 SLGBTQI youth in Saskatchewan by providing vital services such as social supports groups, leadership, and advocacy. We're concerned about your policy announced on August the 22nd, which is not the result of meaningful consultation or grounded in any good quality evidence about the best interests of students." Well, that's a pretty bold claim. I think Egale is upset that maybe it was not consulted as much as it would have liked to have been consulted. Certainly parents were very likely consulted. I don't know for sure. But parents are rightfully concerned about their younger children, and the Justice Center has experience in this whole matter. 5 years ago, we fought against a law that was passed by the government of the day to keep parents in the dark about what is going on with their own children at school. And there was a teenage girl, autistic, very vulnerable. She got recruited into a gay-straight alliance. And of course, the law said that it was illegal for parents to know what goes on inside a gay-straight alliance, which meant parents could not know what kind of political activists could be coming into those meetings, what is shown or presented to those students, whether pornography is presented to those students, what kind of transgender ideology is presented to those students, whether there's bullying taking place within a gay-straight alliance. Nothing, complete secrecy, which is insane, because what parent would allow their child to join a ballet class or a hockey team or a soccer league if they said, oh, by the way, there's going to be some secret meetings taking place where people that you don't know and whose identities you will never learn will get to talk to your child in secret, and you won't know who it was that talked to your child or what was said. So we have secret meetings as part of our ballet, hockey, soccer. I mean, what parent would sign up their kids to a martial arts class if it was announced that there was going to be some secret meetings taking place? Nobody would do that. And yet this is exactly what was implemented in schools in Alberta. So this vulnerable young girl was severely damaged because she was encouraged to believe that she was a boy. She was encouraged to use a boy's name, wear boys' clothing, and all of this was kept from her parents. And she became suicidal. Fortunately, the story has a happy ending. The parents found out, they were able to intervene, and they were able to rescue their daughter from this school. They homeschooled her for a while, put her into a much better school, and she's now well-adjusted, happy 18-year-old or thereabouts, and so that dark chapter has been closed. The problem with Egale and some of these other groups is that the underlying thing that is beneath everything in the letter is this notion that parents are dangerous, and that political activists and social workers and teachers and bureaucrats and politicians are all safe and trustworthy, and parents are dangerous, abusive, and untrustworthy. That is the underlying premise of the entire letter. And that's false, because the truth is nuanced. There are some horrible parents who are abusive, physically abusive, emotionally abusive, sexually abusive. There are a very small number of very terrible parents. That cannot be used as the pretext for taking away the rights of all parents to guide and direct the education and the moral upbringing of their own children. It's outrageous. It would be on par with saying that because a small number of drivers are driving recklessly or driving impaired, therefore, we're going to make it illegal for anybody to own or drive a car because you've got a few bad drivers on the road who are the minority, or certainly the ones who are extremely dangerous or impaired. They're a minority. And this is the same thinking here. Parents are dangerous, abusive. We have to protect children from their own parents. And the flip side is the idea that all teachers, all social workers, all political activists are all 100% safe. Well, that's not true either. From time to time, there are teachers who sexually abuse children. Thankfully, the number is very, very small. You've got political activists that get into trouble for mistreating children. The truth is nuanced. You've got some bad apples in every group. So the underlying premise of the letter is that parents are dangerous and children need to be protected from their own parents. And every assertion in this letter is predicated on that.
Is this a demand letter? Is that how you'd characterize this?
Yes.
It is. So
it's a demand letter that they want the government to voluntarily consent to drop the policy by 5 p.m. on August the 30th. And if the government fails to do that, they're going to file a court application. And let me go through some other parts of the letter. If this policy is implemented at the imminent start of the school year, this policy, that being policy that children under 16 cannot unilaterally change their names or their personal pronouns without the parents' knowledge and involvement. This policy will cause devastating and irreparable harm to gender diverse students under 16 years old who do not feel safe coming out at home. Again, it presupposes that the only way to help gender confused children is to encourage them to take puberty blockers and live out an identity in the opposite sex and get themselves lined up for surgery so that you can get breasts and testicles getting chopped off to satisfy the ideologues. And that again is the underlying premise, that the only way to help gender confused children is to cut parents out of the picture. The truth is that, and this is Dr. Ken Zucker, perhaps Zuckerman, I'd have to check. He worked at the Gender Identity Disorder Clinic or Gender Identity Clinic in Toronto for many years. And he testifies to the fact that something like over 95% or over 90% of gender confused children, by the time they're 18, they feel comfortable with the body that they were born with. They feel comfortable with their birth gender, their biological gender. A lot of those kids will be same-sex attracted, but he helped those children for many years until he was unjustly terminated, and he did get a victory in court or a settlement, and there was a public apology. So he was unjustly terminated from his position because of ideology. But for many years, he worked with these children and helped them to find peace with their birth gender. And that worked very well. It's only in recent years that this transgender ideology has become very dominant, and I hope that that's a temporary phenomenon.
There's definitely some pushback. I noted an article a couple of days ago that Ontario is basically going the same way. And of course, famously, in New Brunswick, they brought in a policy that, was pretty mild, actually, but there was tremendous pushback initially politically. But another article appeared just recently saying that the attempt to get rid of the premier based on his stance against them not informing parents has failed. So obviously he's got the support of at least the people that they can find, to poll. So obviously there's pushback going on, and it's sweeping across the country.
I certainly hope that the New Brunswick government will stay firm and not be intimidated into backing down from what is a very reasonable, very legitimate, in my view, entirely charter compliant policy of saying that children under the age of 16, cannot unilaterally or under the guidance of only political activists who are promoting transgender ideology, as if those are the only safe people, as if those are the only people that care about students. Again, the love that parents have for their own children is far greater than any amount of love that Egale might have for other people's children. I mean, certainly Egale has a right to its opinions, and they can advocate for what they want. But the underlying reality is that parents love their own children more than anybody else, and we cannot. The fact that a very small number of parents are abusive cannot be pretext for undermining parental rights.
Right. Well, that was interesting. You should use the word rights there. There was an article that appeared, I think it was in the National Post, from a parent, about a parent in Saskatchewan, where they were claiming that they had some kind of constitutional or charter right to have their children transition. And I didn't see that specified anywhere in the article, but I guess they're making that claim. Do they make that claim in the letter?
Absolutely.
Okay.
Yeah, a quote from the letter. On its face, this policy violates the rights of gender-diverse students under the Canadian Charter of Rights and Freedoms. That is a bold claim. In my view, it's a false claim. There is no charter right to withhold information from parents. To the contrary, the right of parents to nurture and educate their own children is part of the Charter Section 7 right to life, liberty, and security of the person. This was laid out very clearly by the Supreme Court of Canada in a case about 10 or 15 years ago, which was a challenge to Criminal Code Section 43, which was the spanking provision, which basically says that it is legal for parents to use physical force in disciplining their children. And the court said that yes, that was legitimate. They rejected a claim by an activist group that wanted to make it across the board illegal for parents to use any kind of physical force in disciplining their children. So that was unsuccessful. And so children, as residents of Canada, children also have a charter rights, of course, but it's different. It's not the same as for adults. If a child doesn't want to go to church, the child does not have a charter right to say that he or she is not coming to church. In contrast to an 18-year-old or even a 17-year-old, 16-year-old mature minor, they would have a freedom of religion that would give them a right to say, I don't want to attend church. But and we can argue where the cutoff should be, but certainly for younger children, you don't have the same religious freedom rights that an adult would have. And it's the same thing with gender transition. It's one thing for an adult, it's one thing for a man to say that he wants his genitalia, he wants to be castrated. It's a very different thing for a 10-year-old, a 15-year-old to be making that kind of life-altering decision as a child. And it's especially worse if that's under the guidance of transgender ideologues who want to keep parents in the dark about what's happening with their own children. So, I'd say don't be intimidated by these claims that somehow a policy that Egale doesn't like is in violation of the Charter. Although obviously it would be the court would make a ruling on that.
Okay, well, this sounds like something that, because they've invoked the Charter rights, we're going to definitely keep an eye on as it goes forward, and it sounds like they're probably going to court. Thanks a lot, John, for bringing us up to date on this. I really appreciate it. And I guess we can call an end to episode 21 of Justice Center Weekly. Thanks again, and I hope to speak to you again soon.
And my thanks again to all of the generous donors who make it possible for the Justice Center to carry out its work every day of defending your rights and freedoms in the court of law and in the court of public opinion. Thanks for that support that makes it possible for our lawyers and paralegals and communication staff to do their good work every day.
Take care.